Hello, I'm delighted to welcome you to the third webinar in our oil and gas series, in which we'll provide an overview of recent cases with implications for upstream contracts. By way of introduction, I'm David Anderson, and I'm a partner in the commercial litigation team with a particular interest in the energy sector. What I'd like to do today is to examine a number of cases which have been decided over the last 12 months or so, to highlight the key facts and legal points of each case, and to identify the lessons which can be learned and applied in the oil and gas industry. Today, we're going to look at 5 cases and consider the practical implications of each one. The cases are Transocean Drilling UK, which was an appeal case discussing the exclusion of consequential loss and specifically the recoverability of spread costs, and contrast it with Scottish Power against BP Exploration, which also considered a limitation of liability clause, but reached a different conclusion. In OMV Petrom was another English appeal court case, which looked at calculating damages for a claim for deceit, the principles, authorities, and how to apply them. Vitol against Africa Oil and Gas Corporation was a complex first instance case that has a simple issue at its heart. What is the definition of the commencement of drilling? And finally, we wanted to look at Adamantine Energy against Bowleven, which considers the contractual interpretation of provisions relating to a drill or drop date vote. We'll begin with Transocean Drilling against Providence Resources. This was an English appeal case heard in April of this year. The facts are fairly simple. Transocean was the owner of a rig and contracted with Providence to drill a well off the southern coast of Ireland. Drilling was suspended for a period of 6 weeks, principally due to problems with the rig, in particular the misalignment of part of the blowout preventer. The suspension gave rise to disputes, one of which was Providence's ability to recover additional overheads or spread costs resulting from the extended period of work. These costs included costs of personnel, equipment, and services contracted from third parties, which were wasted as a result of the delay. The key clause was the limitation of liability in Clause 20 of the contract, which largely followed the standard logic form with only minor changes. The relevant part of the clause defined consequential loss as any indirect or consequential loss or damages under English law, and loss of deferment of production or loss of product, and then went on to say loss of use, including without limitation, loss of use or the cost of use of property, equipment, materials, and services, including without limitation, those provided by contractors or subcontractors of every tier or by third parties, loss of business, and business interruption. Now, at first instance, the judge held that the terms of the clause were not wide enough to exclude the recovery of the spread costs, and that therefore Providence was entitled to recover those costs. This was for a number of reasons. First, the spread cost could not properly be characterized as loss of use. Second, there was a presumption that the parties did not intend to exclude a loss caused by a straightforward breach of contract, because otherwise the contract would be robbed of any content, such that Transocean could breach its terms with impunity. Third, since the clause was being relied upon by Transocean, it should be construed contra preferentum, i.e. against Transocean as the party that was relying upon it. Fourth, and finally, the list of losses set out in the brackets should be construed justum generis, i.e. the costs which Providence was prevented from recovering should be restricted to those costs which fell within the category of loss of use. Spread costs were not a loss of use, and therefore the costs were not excluded by the limitation of liability. As can be seen from this list, the judge at first instance sought to analyze the clause by reference to a number of rules of interpretation, and use those rules to determine the intentions of the parties. This approach is typical of a long line of cases dealing with consequential loss, where the courts have assumed experienced business people know how the phrase has been interpreted, and therefore understand what the phrase consequential loss means in a legal context. Now, the decision was appealed, and when the matter came before the appeal court, their lordship took a very different line. The starting point for the appeal court was the words used by the parties when construed against the contract as a whole. In the appeal, the court began by analyzing the not-for-naught provisions within the contract and concluded that the parties had put in place a sophisticated scheme for allocating risk, which involved each one being liable for certain categories of loss, regardless of whether the loss had been caused by one party rather than the other. The effect of these provisions, when read with Clause 20, was that Transocean and Providence each agreed to indemnify and hold the other harmless from its own consequential losses, and thus accepted full responsibility for them. The issue for the Court of Appeal was therefore whether the wasted spread costs incurred by Providence were consequential losses within the meaning of Clause 20, while on the face of it, Clause 20 was a typical exclusion clause with parties disclaiming liability. The Court pointed out that it had certain characteristics which differed from a typical clause. The Court said that the parties are of equal bargaining power and have entered into mutual undertakings to accept the risk of consequential loss flowing from each other's breaches of contract. The clause was not, therefore, to be construed restrictively in order to avoid commercial oppression. Instead, as was re-emphasized by the Supreme Court in Arnold against Britain, the Court held that particular importance must be given to the language chosen by the parties to express their intentions. The Court then analysed the words of Clause 20. They noted that loss of use naturally refers to the loss of the ability to make use of some kind of property or equipment owned or under the control of the parties. However, in this case, the parties made it clear by their words in brackets that follow the terms loss of use that its scope was intended to be much wider than that. The Court considered that the natural meaning of the words the parties have used is apt to include wasted spread costs. The Court of Appeal criticised the High Court's use of the contra preferentum principle and held that the contra preferentum rule had no part to play when the words used by the parties are clear and the clause in question favours both parties equally, especially when they are of equal bargaining power, as was true in this case. Similarly, the Appeal Court was wholly unimpressed by the judge's use of the justum generis rule because it ignored the fact that the parties had chosen to use the phrase without limitation on two separate occasions in the operative part of the clause. Fundamentally, the Appeal Court's approach was to emphasize that the Court should be reluctant to override the parties' intentions. In doing so, they said, the principle of freedom of contract, which is still fundamental to our commercial law, requires the Court to respect and give effect to the parties' agreement. Basically, the Court's view was the parties were free to make agreements as they see fit, even if they might be viewed by a court as being unreasonable, as long as the words used are clear enough. On this basis, the Court of Appeal allowed the appeal, and the spread costs were held to be excluded by the consequential loss provision. Now, this case emphasizes the importance of clear and unambiguous language when drafting contracts, especially with regards to clauses that allocate liability. It also confirms the Court's move away from what might be regarded as artificial rules of interpretation towards a more literal approach to interpreting contracts. However, it also shows that the Court is less willing to place an emphasis on interpreting the clause so as to achieve a commercial outcome. If the parties wish to make a bad bargain, they are free to do so, and the Court is not entitled to interfere. Effect will be given to the words used. Now, I think this case can be interestingly compared with the decision in Scottish Power against BP Exploration. And the case is interesting insofar as the decision in Transocean at first instance was one of the authorities relied upon by Mr. Justice Leggett in holding that an exclusion of consequential loss was not sufficient to prevent Scottish Power from recovering certain categories of loss, although the clause in question in the Scottish Power case was in different terms to the one considered by the Court in Transocean. In the Scottish Power case, the Court was asked to decide whether Scottish Power was entitled to recover the cost of purchasing replacement gas following the shutdown of the Andrew field. Scottish Power was a party to 4 long-term agreements for the sale and purchase of natural gas from 4 companies which owned the right to produce gas from the field. The field did not produce for a period of approximately 3.5 years, and during that period Scottish Power was obliged to purchase replacement gas from alternative suppliers. Importantly, the contract provided that in any month where there was an under-delivery of gas, Scottish Power's remedy was to obtain what was called default gas. This was gas which was to be supplied in a subsequent month at 70% of the contract price. The question arose as to whether this was Scottish Power's sole remedy for the failure to deliver gas whilst the field was shut down, and whether Scottish Power was entitled to recover the difference between the price it has contracted to purchase the gas from the Andrew field and the price it required to pay to purchase gas from alternative suppliers. The case was concerned with a number of different issues, but the point I'd like to look at today is the court's approach to the interpretation of the limitation of consequential loss. The approach taken by the court, and it's on the screen, was that it should, in ascertaining what reasonable people in the situation of the parties expressing a shared intention would have meant by the words used, the court takes account of the natural and ordinary meaning of the clause in question, any other relevant provisions of the contract, the overall purpose of the clause in the contract, the facts and circumstances known or assumed by the parties at the time that the document was executed, and commercial common sense. And again, the judge was founding on the decision in Arnold against Britain. The court also said that there are also certain presumptions of law which courts apply in determining what is to be taken as the intention of the parties. A presumption relevant to this case is that each party to the contract is to be entitled to all those remedies for its breach as arise by operation of law, so that sufficiently clear language is required to exclude or modify the availability of such remedies. And the important point to make there is that the court is talking about a presumption, so it is a presumption which can be disturbed by the words used by the parties in the contract. So having established the approach it wished to adopt, the court turned to examine the clause in question. The relevant clause was Article 4.6, which provided as follows: save as expressly provided elsewhere in this agreement, neither party shall be liable to the other party for any loss of use, profits, contracts, production or revenue, or for business interruption, howsoever caused, and ever where the same is caused by the negligence or breach of duty of the other party. At the time the Scottish Power decision was issued, the Transocean appeal had not yet been heard, and the judge sought to rely on some of the reasoning in Transocean which was subsequently overturned on appeal. In particular, the judge at first instance in Transocean had interpreted the expression loss of use as connoting the loss of expected profit or benefit to be derived by the claimant from the loss of the use of property or equipment which the defendant had contracted to supply. The judge in Scottish Power said that if Article 4.6 was to be construed as the Andrew owners contended, the exclusion would cover all losses which Scottish Power might conceivably suffer, rather than, as is plainly the intention, in his view, excluding only certain types of loss. Furthermore, the approach in Transocean drilling and other cases supported in the judge's view the conclusion that the expressions loss of use and loss of production are directed to future use of the natural gas which the sellers agreed to deliver. Those expressions did not apply to the cost of buying gas from alternative sources to replace the gas which the Andrew owners ought to have supplied. Now, care has to be taken when comparing the two cases because the relevant clauses are in different terms. However, the approach adopted by the court in Scottish Power appears to have reached a different conclusion to the approach taken by the Court of Appeal in Transocean, particularly with regard to how loss of use should be characterised. Interestingly, the Scottish Power decision has been appealed, and we'll have to wait to see how the appeal court approaches the interpretation of this clause in light of its decision in Transocean. I'd now like to look at our next case, which is OMV Petrom against Glencore International. It's another English appeal case and was heard in July of this year. The case revolves around calculating damages for deceit. Between 1993 and 1996, Glencore made about 80 shipments of oil to OMV Petrom. The crude oil was principally of three different grades: Iranium, GOSM, and Urals. These were described as brands in the judgment. 32 of the 80 shipments, however, were blends of various crude oils which resembled brands in yield but were provided at a lower cost to Glencore and thus made them more money selling them on. Documents such as bills of lading, certificates of conformity, certificates of insurance, certificates of quality and quantity, and commercial invoices all describe the blends as Iranian or GOSM brands. The total price paid for the cargo was over $430 million. It was submitted by Petrom that to calculate damages, the market value of the blends, as at the date of the bill of lading, minus a discount per barrel to reflect the fact that the 32 blends were not recognized brands, or even the same 32 blends, should be subtracted from the price paid for the cargo. This was called the valuation approach. Petrom submitted that the discount should be $1.25 per barrel, while Glencore submitted that the discount was wrong in principle, and in fact it should be no more than 50 cents per barrel. At first instance, the High Court reached a discount of $1 per barrel, resulting in damages of just over $40 million. The basis of the discount was that anyone buying an untried blend would open themselves up to the risk of reduced output when compared to the brands, damage to the machinery of the refinery, or at worst, a fire. Glencore submitted that the discount was wrong in principle, as nothing untoward happened. To make a deduction for risk which did not actually occur would be to compensate Petrom for a loss which it might have suffered, but did not in fact suffer. Glencore instead submitted that the damages should be calculated on the comparative yield approach. If there had been no deceit, Petrom would have brought brands and obtained a certain level of gross product worth. The true measure of damages, it was submitted, was the loss in gross product worth Petrom suffered by buying blends rather than brands. Glencore's experts came to values of just over $5 million and $6 million, substantially less than the $40 million found payable in the High Court. The Court of Appeal found that the basic measure of damages for deceit was the price paid less the benefits received as a result of the transaction, which will be its value as at the bill of lading date. This was taken from an earlier decision of the House of Lords, Smith New Court Securities against Citibank. In the Petrom case, everybody agreed that the bill of lading date was the appropriate date. And the House of Lords in the Smith New Court case recognized that the value might be taken at a later date than the date of acquisition if it was necessary to give full compensation to the person deceived. Before the Court of Appeal, Glencore submitted that the same approach could be taken when the buyer's position was better than what was feared at the time of the purchase in order to avoid overcompensation. In reaching its decision, however, the court rejected all of Glencore's authorities and examples for this premise, and said they all ignored the fact that as a consequence of the fraud, the buyer will still have paid more for the crude oil than he would have done if he had known the truth. It was the difference between the price paid and the actual value at the bill of lading date which represented the loss. The court also rejected Glencore's submission that the comparative yield approach should be used. Petrom's complaint was not that the relative yield of the blends was less than the brands. It was that they had had to pay more for the oil than it was worth on account of the seller's deceit. Additionally, as Glencore's own experts accepted, gross product worth was not a determination of value, as it didn't take into account the risk of something untoward happening with the untested blend. The market value, however, would take account of this risk. The Court of Appeal found that the High Court made no error of law and reached a decision which is open to it and dismissed the appeal. Now, a key principle to take from this case is that the fact that no risks apparent at the time of the deceit actually came to fruition does not affect the fact that the buyer was induced to pay too much and therefore is due compensation. Additionally, it's a clear signal that damages in cases like this will continue to be assessed according to the Smith New Court principles. The court also reiterated the compensatory principle that asking a fraudulent seller to make such compensation is consistent with a policy of discouraging intentional wrongdoing. I'd now like to move on to the decision of Vitol against Africa Oil and Gas Corporation. This is the first instance decision from the High Court, the Commercial Court in England, again heard in July 2016. The issue at the heart of Vitol was a simple one. Did the term commencement of drilling mean the initial turning of the drill bit into the seabed, or spudding, or did it mean a broader concept of the drilling process as a whole, which commences with the mobilization of the rig? In this case, there was a production sharing contract made with the Republic of Congo and a related JOA made between several companies. Vitol was a member of the PSC through a subsidiary named Raffia. Africa Oil and Gas Corporation, through a sale and purchase agreement, purchased Vitol's shares in the project. Under the terms of the PSC, a well had to be drilled before progressing to the next exploration period. A well was proposed called Lydekker East Well. It was voted on, and a drilling rig became available at short notice. On 21st May 2013, the mobilization of the drilling rig from Rio de Janeiro to Congo commenced. The well was spudded on the 20th of July 2013. Now, the cash consideration payable under the SPA between Vitol and EWCA was $12.6 million. There was a balance known as the deferred consideration, which was due under certain circumstances stated in Clause 7.1, which provided that the purchaser shall pay the seller the deferred consideration if one of the following conditions is satisfied. Now, the relevant part of the clause went on to say that the drilling of the Lydekker East well is not commenced before the date of expiry of the second exploration period. The deferred consideration amounted to $7.4 million. When EWCA executed the SPA in January 2013, there were 5 months remaining for the drilling of the well to commence, as this was the point at which the second exploration period expired. If commencement of drilling was taken to mean spudding, the spudding date, which was 20th July 2013, fell outside the 5-month period, and EWCA were obligated to pay the deferred consideration if it was taken to mean mobilization of the rig, which commenced on the 21st of May 2013, EWCA would not have to pay the deferred consideration. The court in its decision considered the only relevant authority on contractual interpretation to be the most recent Supreme Court decision in this area, which I've mentioned several times already today, which is Arnold against Britain. The judgment quoted paragraphs 15 to 22 of Lord Neuberger's judgment in Arnold, which made reference to the natural and ordinary meaning of the words. The court in Vitol found that there was a natural interpretation of the words commencement of drilling, and that it was the physical penetration of the seabed, i.e. spudding. This was to be distinguished from preparations for drilling, as drilling itself is not a momentary process, and so it's perfectly sensible to speak of when drilling starts in the spudding sense and when it stops. The court distinguished this case from several American cases EWCA referred to, which had held that drilling started when the preparation for drilling commenced, and in rejecting those cases it said they all proceeded from an original error. They also turned upon different provisions than were being considered in this particular instance. Other arguments of construction of the contract were also rejected, such as looking at the underlying commercial purpose, unfairness, liability rationale, drafting infelicities, and the interpretation of the contract contra preferentum. The court held that one must return to the natural meaning of commencement of drilling. Drilling, therefore, did not take place until spudding, and therefore not before the expiration of the 5-month period. EWCA had to pay the deferred consideration of $7.4 million to Vitol. While also clarifying the definition of commencement of drilling, this case serves as notice to drafters to use industry-recognized terms such as spudding to enhance contractual certainty. Again, this case is typical of the shift which we've seen from a focus on the commercial purpose of the relevant contract to a greater emphasis being placed on the actual words used by the parties. Now, our last case today is Adamantine Energy against Bowleven, which is another first instance case in the High Court in England. The action involved a dispute as to whether Adamantine was entitled to acquire from Bowleven a 50% participating interest in a block as a result of a drill or drop vote on the 25th of February 2015. The background was, in May 2012, Adamantine entered into a production sharing contract with the government of Kenya in respect to an area known as Block 11B. The PSC provided for the exploration phase to be divided into 3 periods. The initial exploration period was 2 years, a first additional exploration period for a further 2 years, and a second additional exploration period for an additional 2 years. Each period had minimum spend and work obligations for Adamantine, and to progress to the next period, it had to make a written application to the Minister of Energy not later than 1 month prior to the expiry of the previous exploration period. At the beginning of each exploration period, Adamantine was obliged to post a guarantee of the full minimum work and expenditure obligations for the forthcoming period. Now, under a sale and purchase agreement, Adamantine assigned a 50% participating interest in the PSC to Bowleven in return for Bowleven's agreement to carry the minimum cost of the exploration phases. Clause 8 of the SPA was the so-called drill or drop provision. It provided that no later than 3 months before the expiry of the existing exploration period, there should be a management committee meeting at which each party should vote whether it wished to proceed to the next exploration period. If both wished to proceed, 1 month notice would be given to the government. If neither wished to do so, Adamantine was to give notice to the government to relinquish all interest in the block. Importantly for this case, if one party wished to proceed when the other did not, the withdrawing party was obliged to assign its 50% participating interest to the other at no cost. The initial exploration period was due to expire on 28 August 2014, but due to delays in acquiring the 2D seismic data, an extension was granted to 26 May 2015. A serious attack in early 2015 by Kenyan locals on a camp set up by one of the subcontractors made it apparent to both parties that the minimum work obligation and expenditure was not going to be completed before the expiry of the initial exploration period. Despite an extension being sought from the ministry, Adamantine was still placed the drill or drop vote on the agenda for the 25th February Management Committee meeting, 3 months before the expiry of the initial exploration period as required by the SPA. The meeting took place by phone, and a vote was called by Adamantine, who said that they were voting yes to move to the next period. Bowleven discussed matters and gave a conditional yes, the condition being the granting of the time extension. Adamantine replied, indicating a conditional vote was not valid and would be treated as a no unless it was changed. Both parties ended the call maintaining their position, with Adamantine's position being a valid drill or drop vote had been held and that Bowleven should have been treated to vote no. Now, before the court, Bowleven's main case was that a valid drill or drop vote was not called. This type of vote could only be to exercise the rights under Clause 2.3 of the PSC, and at that date, both parties knew that Adamantine would have no rights under that clause on or before 26 May. This was because it was a certainty that it had not by then fulfilled the minimum work and expenditure obligations. Like previous cases mentioned today, the court looked primarily at Arnold against Britain for guidance on construction of commercial documents, and specifically the decision of Lord Neuberger. However, in this instance, the most relevant guidance which they looked at was the commercial rationale of the clause. The court found that this was not merely a vote on whether the parties wished to proceed to the next exploration period in principle. Exploration period was a defined term, and is defined pursuant to Clause 2.3. So therefore, the decision required by Clause 8 of the SPA was whether to enter into the next exploration period by invoking rights under that clause. The court noted that the timetables may give rise to uncertainty 3 months out. Such rights under Clause 2.3 will exist, and there may be circumstances in which a party may have to make a drill or drop decision on incomplete data. The commercial rationale for the voting timetable was to balance two competing needs. Each party's need to have the maximum opportunity to assess the existing data before being required to make the drill or drop decision, and each party's need to have sufficient time to make the arrangements for the next exploration period should a party elect to continue with exploration. Both parties at the meeting on 25th February expressed that there would be no rights arising under Clause 2.3, as both parties knew there was no prospect of completing the obligations by 26th May. Adamantine's construction had the consequence that if Bowleven had voted yes and the government had given the parties the extension sought, the parties would have been irrevocably committed to moving to the next period at the end of the extended period, and that without a vote and without the results of the data collected during the period. This was the effect of the clause making it mandatory to require a Clause 2.3 notice in the event of a yes vote. It followed that what had happened on 25th February was not a vote contemplated under Clause 8, and did not have the consequence that Bowleven was obliged to transfer its 50% interest. While the decision was largely based on the wording of the specific SPA and the PSC, it showed the advantage of placing the parties' obligations in the SPA in the express context of rights existing under the PSC. It allowed the court to establish the commercial rationale of the clause and the natural and ordinary meaning of the rights that the clause conferred. It's also clear from this and other cases today, the courts, when interpreting contracts, will primarily look at the Arnold against Britain decision as a guiding precedent, so drafters should draft with Lord Neuberger's guidance in mind. So where does this take us? In simple terms, the approach adopted by the court to the interpretation of contracts has taken a subtle shift. As can be seen from the Bowleven decision, the courts will still look at the commercial rationale for a particular provision, but their starting point, and sometimes their end point, will be the words used. If those words are clear, as in Transocean, the court will give effect to them. Even if the words used create a bargain struck by the parties which appears to be uncommercial. In practical terms, this means that it is more important than ever to state in as simple a term as possible what you want to achieve, and to avoid relying on any of the rules of interpretation which have historically found favour of the courts. It also means that it is not always safe to rely on the underlying commercial rationale to agreements to rescue any errors in the drafting. Well, I don't appear to have any questions. If people do wish to address questions to me after the conclusion of the webinar, please feel free to contact me directly. Otherwise, all that remains is for me to thank you for attending. I hope that you find this useful and that we'll have the opportunity of having you attend one of our other webinars. Thank you very much.